Ngunit sa huli, palagi babalik.
One of the basic principles of void marriages would be Article 4 of the Family Code, whereas it states that an absence in any of the essential or formal requisites shall render the marriage void ab initio except in cases of Article 35, Paragraph 2. Now then, what would constitute an absence in the essential and formal requisite? First, let us go through each requisite. Essential requisites of a marriage would be first, the legal capacity of contracting parties who must be male and female. The legal capacity being referred to here includes being in the age of majority, being able to remarry with a valid judicial declaration of nullity, and others, as well as the sex of the person being contemplated, which must be male and female. And the second requisite, which is consent freely given in the presence of the solemnizing officer. There should be consent, which was first freely given, meaning the party willingly and deliberately entered into a marriage, and it should also have been second, made in the presence of solemnizing officer. So if there is no consent at all, such as the total absence of it, the marriage shall be void ab initio. Now, for the formal requisites of a marriage, we first have the authority of the solemnizing officer. Those who are authorized by law to be a solemnizing officer are listed in Article 7 of the Family Code, which are judge, priest, rabbi, imam, and etc. The formal requisites here would be the authority of the solemnizing officer, not their mere presence. Thus, when there is no authority of the solemnizing officer, the marriage is void unless it has been contracted in good faith by either one or both parties. This exception also contemplates the exception of Article 35, Paragraph 2 and Article 4. Thus, as a general rule, any absence of the formal or essential requisite makes the marriage void. However, in the case where the solemnizing officer does not have the authority, but either or both parties believe in good faith that he has the authority, will not affect the validity of the marriage. Formal requisite is a valid marriage license except in the cases provided for in Chapter 2 of this title. Thus, when there is no marriage license from the state, such as the local civil register, the marriage is considered as void except for the cases provided in Chapter 2 as listed below. The last formal requisite talks about the marriage ceremony. No prescribed form of a marriage ceremony is required by the Family Code. What is important is that there is a marriage ceremony with the authorized solemnizing officer, and the parties with their personal declaration, which does not have to be vocal, by the way, as covered by the other requisites. Without this, the marriage will be considered void. Furthermore, the mere absence of two witnesses of legal age is an irregularity which will not affect the validity of the marriage.
Ngunit sa huli, palagi babalik pa rin sa yakap mo hanggang sa huli.
Article 35 talks about marriages that are void from the beginning. So as you've seen in the video, that's one example of a marriage that is void from the beginning, because even if the parents consented, Pat was 16 years old and Amiel was 40 years old. So it is void ab initio. So to easily understand or easily recall marriages that are void from the beginning, that we made a mnemonic. It's 18 big legal mistakes. Sorry, ma'am. So 18 is for paragraph 1. Those contracted by any party below 18 years of age, even with the consent of parents or guardians, are considered void ab initio. Big is for paragraph 4, those bigamous or polygamous marriages not falling under Article 41. Legal is for paragraph 2, those solemnized by any person not legally authorized to perform marriages unless such marriages were contracted with either or both parties believing in good faith that the solemnizing officer had the legal authority to do so, then it is not void ab initio. Mistakes is for paragraph 5, mistake in identity, those contracted through mistake of one contracting party as to the identity of the other. Sorry is for paragraph 6, so letter S is for subsequent marriages that are void. So those subsequent marriages that are void under Article 53. Ma'am is for paragraph 3. Letter M is for marriage solemnized without license. So those solemnized without license, except those covered in a specific chapter. So recall that in Article 3, one of the formal requisites of marriage is a valid marriage license. So absent any essential or formal requisites, then the marriage is void. And there is a chapter in the Family Code which discusses marriages that are exempt from marriage license. So again, for Article 35, it's 18 big legal mistakes. Sorry, ma'am.
I can conclude that she is definitely psychologically incapacitated.
Okay, so this, Your Honor, proves that Mrs. Amiel Ibarreta is psychologically incapacitated to perform her duties and obligations to her husband, Mr. Amiel Ibarreta.
Yes, Your Honor. Mrs. Ibarreta has always been using drugs, even before our marriage. The reason why I married her in the first place was she promised me that she wouldn't do drugs anymore. Our children essentially have no mother. Because of her drug usage, she's always been fighting with me and the kids, and she's always out partying.
Objection, Your Honor. Hearsay.
So there are three main characteristics of psychological incapacity. The first one is that it has no definition. The second one is that the ground is restricted to comply with essential marital obligations. And the third is that it must be present at the time of the marriage celebration. This can be easily memorized by the mnemonic of NGP. So for the first characteristic, when you mean by no definition, it means that psychological incapacity will be determined on a case-by-case basis, meaning that the determination of psychological incapacity will depend on the facts of that particular case. The absence of a definition is actually intentional because situations vary from one case to another, and even if we do have a definition for psychological incapacity, it will actually straitjacket the concept. Because of this, the courts will be the ones who will determine whether or not there is psychological incapacity. For the second characteristic, when we mean by essential marital obligations, it must mean that the psychological incapacity alleged must be serious and effective, that it prevents the spouses from having a normal marital life. Psychological incapacity doesn't refer to mental faculties and has nothing to do with consent. Furthermore, it refers to the obligations attendant to marriage. For the third characteristic, a psychological incapacity must be present at the time of the celebration of the marriage, or it can manifest later on during the marriage. Furthermore, because the marriage is void due to psychological incapacity, it cannot be cured by cohabitation, nor likewise can it be ratified to make the marriage valid. In the case of Andal v. Andal, the Supreme Court restructured the Molino Doctrine, which is the test to use to determine whether or not there is psychological incapacity. So for the first part is the burden of proof, wherein the plaintiff has the burden to prove that the spouse has psychological incapacity. Due to this, the quantum of evidence needed is raised from preponderance of evidence to proof beyond reasonable doubt. The second part is the personality structure, because the Supreme Court stated that psychological incapacity does not mean a mental or personality disorder. Because of this, it is not anymore needed that the psychological incapacity is proven by expert testimony by psychologists. Rather, it is sufficient that the plaintiffs use ordinary witnesses. Because of this, it is the judge who decides if there is a true and serious incapacity to assume essential marital obligations. And for the third part is that incapacity must be proven to be existing at the time of celebration. It means that the illness was existing when the parties exchanged their IDs, even if such capacity became manifest only after its solemnization. It must be proven through juridical antecedents, which may consist of testimonies describing the environment wherein the allegedly incapacitated spouse grew up in, or that attributed to the alleged psychological incapacity. But the fourth part is that incapacity must be medically or clinically incurable. When you mean by incurable, it means in a legal sense, meaning that incapacity must be so enduring and persistent that the couple's personality have become incompatible and antagonistic. But the fifth part is that the illness must be so grave that it disables the spouse to assume the essential marital obligations of the marriage. It means that the psychological incapacity isn't a mere refusal or neglect, but a genuinely serious psychic cause. For the sixth part is that the essential marital obligations refer to Articles 68 to 71. It means that those marital obligations are limited between the spouses. And lastly is that interpretations of the National Appellate Matrimonial must be given great respect by the courts.
Oh no, we're in love.
Article 37 talks about incestuous marriage which are contracted between an ascendant and a descendant of any degree, as well as brothers and sisters, regardless of whether they are full or half-blood. This is because incestuous marriages are grossly indecent, immoral, and inimical to the purity and happiness of the family and the welfare of generations. So a marriage between 30 and Catherine will be incestuous as it is a marriage between an ascendant and descendant. A marriage between Elijah and Amiel will also be incestuous as it is done between a brother and a sister. The reasons behind the prohibition of incestuous marriage are because 1. It's abhorrent to the nature, 2. It brings confusion of rights and duties incident to family relations. For example, if there's a child between a union of a daughter and a father, then the mother is also the sister of the child. 3. It produces deficient and degenerate offsprings which would amount to serious deterioration of the race that could have tragic consequences. And also because 4. Such social prohibitions promote the solidarity of the nuclear family, such as how it controls rivalries and jealousies within the family unit.
Good evening, everyone. Here are the intro. Is your marriage against public policy? We have here a special guest. Would you mind introducing yourself?
Yes, I'm Amiel Ibarreta, and since I've been adopted by my parents, I want to look for love.
Wow, he's looking for love. So let's see your options. Option 1, the legitimate daughter of your adopters. Change. Option 2, your adoptive mom. Let's see your third option. Your adopted sister. What's your fourth one? Yourself? Well, it looks like you don't have any choice since all of them are against public policy.
Considering paragraph 1 of Article 38 states that marriages between collateral blood relatives, whether legitimate or illegitimate, up to the fourth civil degree, would be considered void. Who can you see would be validly married within the family tree? To simplify things, let's go over who else can't marry. The second paragraph states that marriages between step-parents and stepchildren are also void. This would mean that Amiel cannot marry Pat, considering 30, his adoptive father, remarried Pat, and thus Pat became the stepmother. The third paragraph is between parents-in-law and children-in-law. Here we have Catherine and Alden, whose children are 30 and Mika. 30 married Julia, and then after her death, married Pat. Alden cannot marry Julia or Pat. Catherine cannot marry Sunho. Fourth is between the adopting parent and the adopted child. Here we have Amiel, the adopted son of Julia and 30. Thus, he cannot marry Julia when she was still alive. Fifth is between the surviving spouse of the adopting parent and the adopted child. The surviving spouse of the adopting parent would then be Amiel, as Dane has died, and the adopted child would then be Unje, as she was only adopted by Dane. Sixth, we have between the surviving spouse of the adopted child and the adopter. The surviving spouse, if Minji had died, would then be Ricky. Minji's adoptive parents were Esther and Jay. Thus, Ricky and Esther cannot marry. Seventh, we have between an adopted child and a legitimate child of the adopter. Here we have Amiel, whose siblings are Elijah and Esther. Elijah is the legitimate daughter of Julia and 30. Thus, Amiel and Elijah also cannot marry. And eighth, between the adopted children of the same adopter. Considering Amiel and Esther were both adopted by Julia and 30, they also cannot marry. Lastly, it is also void wherein parties with the intention to marry another killed that other person's spouse or their own spouse. If it was actually revealed that Julia's death was caused by 30 as he wanted to marry Pat, then 30 and Pat's marriage would also be void. So to reiterate my question, who can marry then? You're right, it is Chaewon and Mingyu. Considering if we count starting from Chaewon, it would then go to Elijah and Suhyun, next Julia and 30, then Catherine and Alden, then Mika and Sunho, and then fifth would be Mingyu. Thus, if they are not void in any other articles, they can marry without it being against public policy.
Kuya, tingnan mo na siya. Ang tawa.
A marriage contracted during the lifetime of the first spouse or the subsistence of a previous marriage is bigamous, and thus is null and void ab initio. The prior voidable or annullable marriage must be in fact annulled in order for the parties to validly enter into a subsequent marriage. However, under Article 41 of the Family Code, a valid bigamous marriage is possible if prior to the subsequent marriage, the present spouse obtains a judicial declaration of presumptive death via a summary proceeding. This may be obtained by presenting evidence that the prior spouse has been absent for 4 consecutive years, and this period is shortened to 2 years in case of disappearance where there is danger of death under Article 391 of the Civil Code. These include disappearance aboard a sea vessel, on an airplane which went missing, and that the absent spouse is a member of the armed forces that has taken part in the war. The periods of 4 and 2 years for the presumption of death is only shortened for the purposes of remarriage. Article 391 provides a period of 7 years of absence and not knowing whether the absentee still lives for all purposes except those of succession, which is 10 years. This is also, of course, without prejudice to the reappearance of the absent spouse. Article 42 allows the automatic termination of the subsequent marriage through the recording of the affidavit of reappearance of the absent spouse in the civil registry. So, in order to obtain this judicial declaration, the present spouse must actively conduct a diligent and reasonable search for the absent spouse and, of course, present evidence of the same. The courts have set standards for the establishment of this well-founded belief, which first includes that the present spouse presents the persons from whom he made inquiries, especially the absentee's relatives, neighbors, and friends, to corroborate the information they provided. 2, that they were able to report the missing spouse's purported disappearance or death to police or mass media and provide evidence of the same. And 3, that the evidence shows that the absent spouse is indeed dead and not simply refusing to communicate. This well-founded belief must be the result of proper and honest-to-goodness inquiries and efforts to ascertain the whereabouts of the absent spouse and whether the absent spouse is still alive or already dead.
Amiel, do you take Elijah as your lawfully wedded wife? Do you take Amiel as your lawfully wedded husband? Are you interested in
You said she was dead!
I thought you were dead.
Who did you ask?
A judicial declaration of presumptive death is only required for the purpose of capacitating the present spouse to remarry. However, if the absent spouse reappears after years of absence, he or she may easily terminate any subsequent marriage entered into by their spouse unless there is a judgment annulling the previous marriage or declaring it void ab initio. The reappearing spouse may assert her rights through the execution of a sworn statement or affidavit of the fact and circumstance of such reappearance and recording of the same in the civil registry of the residence, and with due notice to the spouses of the subsequent marriage. Any interested party may file this sworn statement of reappearance, including the present spouse, the parents, children, and even the subsequent spouse of the present spouse. This declaration must of course be authentic and without prejudice to judicial proceedings questioning the reappearance. If the person claiming to be the reappearing spouse is determined to be an impostor, the subsequent marriage will not be terminated. So the absentee's mere reappearance, even if it is made known to the spouses in the subsequent marriage, will not automatically terminate the marriage. The reappearing spouse must take action through the execution of the sworn statement or affidavit in order for this to happen. The first marriage is likewise considered subsisting, not having been judicially nullified or annulled. However, between the 2 marriages, the law shall continue to protect the second marriage, as mere reappearance will not automatically terminate such marriage. In order for the reappearing spouse to assert his or her rights, they must properly follow the requirements of the law. So, the reappearing spouse must file a nullity or an annulment case if there are grounds to do so, in order to be able to enter into a marriage with another person. If there are none, the reappearing spouse has no choice but to live as a married person despite their spouse validly and legally living with another husband or wife. Article 349 of the Revised Penal Code provides the penalty of prisión mayor to any person who shall contract a second or subsequent marriage before the former marriage has been legally dissolved or before the absent spouse has been declared presumptively dead.
Article 43, in relation to the preceding article, the termination of the subsequent marriage shall produce effects specifically to number 1, children, number 2, property regime, number 3, donations, number 4, insurance, and number 5, inheritance. So first, as to the children of the subsequent marriage conceived prior to the termination are considered legitimate. So second, as to the property regime of the subsequent marriage, it shall be dissolved and liquidated in accordance with the family code provisions, depending on their property regime. So it depends whether their property regime is absolute community property or conjugal partnership of gains, then it shall be dissolved and liquidated accordingly. However, if either of the spouse acted in bad faith, the guilty spouse shall not get share in the net profits of the property regime. So his or her share shall be forfeited in favor of their common children. If they don't have any common children, it shall be in favor of the children by previous marriage. And then in the absence of common children or children by previous marriage, then the share of the guilty spouse shall be forfeited in favor of the innocent spouse. Third, donations. So donations by reason of marriage shall remain valid. But if the donee spouse acted in bad faith, the donations made by him or her are revoked by operation of law. Fourth, as to the insurance, as to the designation as beneficiary in an insurance policy, the innocent spouse has the choice of revoking or maintaining as beneficiary in an insurance policy the other spouse who acted in bad faith, even if such designation be stipulated as irrevocable. So lastly, as to inheritance, the spouse who contracted the subsequent marriage in bad faith shall be disqualified to inherit from the innocent spouse, both by testate and intestate succession. So again, it has 5 effects. It shall produce 5 effects as to children, their property regime, donations, insurance, and inheritance.
Excuse me.
Yes?
Are you the bride?
Yes, I am.
Can we talk?
Yeah, sure.
I'm Mrs. Amiel Ibarreta. I'm his first wife. I'm not dead.
What? You said you were dead.
No, I'm not. I just want to get back to my old life. You guys can't get married.
What? We're gonna get married today.
No, you're not. I'm
No,
here.
yes.
I'm alive.
We will get married today.
No.
Please, just let us get married.
Article 44 states that a marriage is void if both spouses contracted it in bad faith. In this case, we see that the husband was in bad faith because he was about to contract a subsequent marriage without a well-founded belief that his first wife was dead. It may even be presumed that he colluded with his first wife in order to get married to his second wife. The subsequent wife was also eager to push through the wedding by trying to convince the first to just disappear, even with the knowledge that she was still alive. This is in relation to Article 41, wherein a subsequent marriage is only valid if it satisfies the well-founded belief that the previous spouse is already dead after the time enumerated has lapsed. If only one of the parties to the subsequent marriage knew that the previous spouse was alive, then the marriage will remain valid. However, Article 44 expressly states that if both parties were in bad faith, then the subsequent marriage is already void.